All right, let's talk about something most people hope they never experience, but honestly, you should know anyway. What actually happens when you get arrested and taken to a police station? You're going about your day, things go sideways, the police show up, and suddenly you're heading to the station. First, you get booked in by a custody officer, usually a sergeant. Their job isn't to interrogate you or solve the case. Their job is to follow the legal procedures. They'll open a custody record which logs everything that happens while you're detained. You and your solicitor have the right to see it under PACE, the Police and Criminal Evidence Act 1984. This record is super important because it protects you if something isn't handled properly. Now, your rights. Whether you've been arrested or you walked into the station voluntarily, your rights are the same. You have the right to free, independent legal advice. And you have the right to let someone know you've been arrested, usually a family member or friend. The police have to make a reasonable effort to contact them. But there's a big caveat. In more serious cases, like indictable offences, the police can delay your right to notify someone, which requires authorisation by an inspector. They can also delay your access to a solicitor, but that's even more restricted. It requires authorisation by a superintendent. Both can only happen if they have proper grounds like risk of suspects escaping, evidence being destroyed, or someone being armed. Even then, the delay cannot go beyond 36 hours. Next, how long can they keep you? For less serious offences, the limit is 24 hours. For more serious ones, a superintendent can extend this to 36 hours. Anything beyond that requires magistrate's approval, and even then, the absolute maximum is 96 hours, 4 days. The detention clock starts ticking from the relevant time, which is usually when you arrive at the police station after arrest. If you attended the station voluntarily and then arrested there, the clock starts ticking from the moment of that arrest. If you're vulnerable, under 18, have mental health issues or have difficulty communicating, the police must call an appropriate adult. They support you, explain what's happening and sit in on interviews. Just remember, unlike a solicitor, conversations with them aren't confidential. When you get to the interview, you have 3 options. 1, answer questions. 2, say no comment. 3, give a prepared statement and then stay silent. Which option is best? It depends. That's why legal advice matters. But under the Criminal Justice and Public Order Act 1994, silence can sometimes lead to adverse inferences, especially if you refuse to explain suspicious injuries, items, or your presence somewhere sketchy. Police interviews must be fair. They can't lie about the evidence, make false promises, or pressure you into answers. After the interview, the police decide whether to charge you or release you. They'll consider the evidence, your behaviour, whether you have previous convictions, and whether you pose a risk. And remember, being charged does not mean you're guilty. You're still presumed innocent until proven otherwise, and you're entitled to a fair trial.